Welcome back to Between Two FARS. I'm Warneke Miller here once again with the amazing Michael Mark and the veteran procurement attorney, Robert Tepfer, who combined, these two gentlemen have almost 90 years of federal procurement experience. And they've been walking us through what it looks like to have litigation filed in front of the Armed Services Board of Contract Appeals. We're now going to start our discussion about discovery in front of the ASBCA. And today we're going to focus on interrogatories, requests for admission, and requests for production of documents. Bob, Michael, what do you think the average attorney needs to know about this type of practice in front of the ASBCA?
I think there's a flow to it, and you need to put them together. And you need to make certain you've got them in the right order and some kind of a logic associated with what you're doing. The request for interrogatories, essentially, it can be combined with document requests. And normally it'll state things like identify and provide the names of all individuals who have knowledge with regard to sentence 2 of paragraph 3 of the complaint. Identify and provide all documents which support allegation, and you speak to the allegation specifically. Two things you're trying to accomplish there. You don't want to be surprised with witnesses that you didn't know about because you'd like to depose them, and you certainly don't want to see them at hearing, and you don't want to be surprised with regard to documents at a hearing that you were unaware of. You always have an obligation to supplement should they stumble upon other documents or find out other knowledge. So there's a continuing obligation right up to the hearing to tell folks. In fact, I've even gone so far as to go back and say I want to depose somebody that you failed to notify me with regard to. The interrogatories should be sworn to. Occasionally, you'll find counsel will swear to it, which you might go to them and say, geez, that's interesting. Are you a fact witness? Because I need the names of the individuals who have actual knowledge of those facts, and you have them swear to it. Subsequently, it flows right into a deposition where the individual may be asked a narrative question, which is broad, and a specific question to the extent that he takes issue or doesn't provide sufficient facts consistent with the interrogatory. You hand them the interrogatory and do the classic, were you inaccurate under oath when you signed the interrogatory, or are you being inaccurate now at this point in time because there's a clear inconsistency? I don't know if Michael wants to speak to requests for admissions, but I love them because you're, again, paring the case down. What do we really disagree with? What are you taking exception to? I want to know that, and the request for admissions permits you to focus on that.
Right. And I agree with that, Bob. One of the things that I find strange is the way the rule is set up in the ASBCA. They have depositions above interrogatories, and that's not the order that we do these things. Start with your interrogatories, and then you go to your depositions. That way you have essentially your question set ready for the witnesses that you're going to depose. The interrogatories are designed to find out, okay, who is it that we're supposed to be deposing? Who are the witnesses? What are the documents? And from that, you can then do your requests for admission. The other thing is the flow of the interrogatories, as you point out, and it's important, is your interrogatories. What are you basing your interrogatories on? What are you going to be asking for? It's everything that's in that complaint. So start with the beginning of that complaint and work your question set through based on every allegation in that complaint. And that way you'll have covered the field. And at that point, you should be able to say, okay, based on what we've got now, we can do requests for admissions, or we'll discover what they're not going to agree to. And then from there, you'll be ready to go to your depositions. So interrogatories first, you get it in writing. The interrogatories are usually pretty specific. You may or may not be asking leading questions, but basically what you're trying to do is find out who are the players, what are the documents, what do they know, and then you can depose them. So then you'll have your oral thing, and you will also have all of the documents available, and you're probably going to run the witness through them, and we'll talk about depositions, I think, later.
What about what they're allowed to ask us for? Are they limited to what kind of documents they can ask us to produce?
Well, it has to have, lead to evidence that would be admissible. The standard rule is having a tendency, even slight, to support a matter and issue.
Right.
One of the things that I think really requires some attention to be focused on is the fact that a lot of times when you're dealing with a program office, they may not tell you everything about their case. So you learn as much from your people being deposed in the interrogatories, which they have to answer, and that's a separate issue, as you will from just sitting down with your people. They'll volunteer a lot of things. You get a program director, you sit them down, the individual may feel like, look, I've seen you around, I don't have to tell you anything I don't want to. Well, that's fun until he ends up in a deposition, and then you get to sit there and listen about your case, and you can do it to the other side as well. So, you learn a lot about your case if you're careful with regard to it. The other thing that I want to emphasize is a lot of folks don't fully appreciate when they're getting ready to do a deposition, that the deposition begins when the individual opposing counsel enters the room. I've seen folks bring experts or people that they knew the witness was friends with, went to church with, whatever, and they'll start talking and they'll find out a lot. So you need to know during your witness prep for deposition, you tell them it starts before you take the oath. You need to understand it's all very serious from the get-go. Okay, and go ahead.
Well, focusing a little bit more on admissions and document production and interrogatories, what would you say is the most important order to do those things? Do you like to have it in a combined document that you're asking for all three at the same time, or do you like to break it out? I heard a little bit from both there. Does it depend on the case?
I think it depends on the case, but I can say that with regard to interrogatories, I like to marry that with the document request, right, because I'm going through it sentence by sentence. They have to prove their complaint. So how are they going to prove their complaint? They're going to prove it with documents. They're going to prove it with witnesses. When they give me the witnesses, I know who to depose on the critical issues. The documents, that's the universe of all documents that they can put into evidence under that, because they swore that's all there were. Okay. Now, what I recommend and what I would do is you build a trial attorney's notebook, and you effectively do an exploded version of the complaint. And for each sentence, you have the documents that they say supported and the names of the witnesses under each allegation. Okay. So when you go into a hearing or you go into a deposition and it's inconsistent, you can flip right to the sentence, to the documents, and to the witnesses and what they said. That's critical. It all ought to fall in line there. If they don't fall in line, otherwise you can be scattered around trying to, I know there's, they didn't give me this document. I know they said something inconsistent in an interrogatory. The attorney's notebook, very carefully tabbed, will have all of that so you can pull right to it. And then you can ask for that document and speak to the Rule 4 tab, whatever, hand them that or, and speak to that issue.
Yeah, that goes back to, I think, our Air Force training. The trial notebook is an extremely valuable tool, and it's something that you're going to build as the case moves on. So you'll start small and it'll get much thicker as time goes on. I tend to think that asking for admissions before you've done interrogatories and gotten the documents is not really a good idea, because you don't have enough yet to be able to say, okay, here's where I think we agree or don't agree, or where the facts show, there's no argument about these facts, so let's get those taken care of. And until you've gone through some discovery, I don't think you're ready to do that. It may come before depositions, it may come after, I don't know. I think it's going to depend on what you've got.
And Michael, what's the added bonus hidden in here? What happens if you make a request for admission and 45 days pass and they don't respond?
It's admitted.
I'm not sure how often somebody's going to be asleep at the wheel like that, but that is an added bonus as you're drafting your request for admissions to think, hey, I'll have a real solid summary judgment motion if they don't respond to these.
And remember, they're doing the same thing to you, so be sure you've got that suspense.
One thing that I would like to emphasize is unless the judge on like a really big case, and I've had them do this, say that the federal rules are going to govern, they don't. Okay. And what that will do is that will open it. I've gotten as many as 100 4-part interrogatories at a shot. Okay. So the 25 interrogatory rule doesn't apply. The other thing that I want to emphasize is at the inception of the case, you need to brief the witnesses involved, the program office, whoever. This is your case. I'm going to give it to you. You're going to respond. I may help you clean it up, just like the other side will clean up their interrogatories, and you need to be cognizant of that, but you're going to do it. And they don't necessarily like that. They like you to do it. And the answer is, I don't have the facts. I can't swear to them, and I'm certainly not going to testify. And so they need to be very much aware from the get-go that they're the ones that are going to be putting together this case, and you are nothing more than a helper.
Well, I hope you've enjoyed this foray into discovery under the ASBCA. Join us again next time when we talk about depositions. Until then.